In the landmark decision of Teddy Bear Clinic for Abused Children and Another versus Minister of Justice and Constitutional Development and Another, the Constitutional Court of South Africa held that criminalization of consensual sexual conduct of adolescents was stigmatizing, degrading, invasive, and violative of human dignity. It observed that punishment of adolescents for sexual expressions that are developmentally normal have a degrading and stigmatic effect on adolescents and infringe their right to dignity, privacy, and was contrary to the best interests principle. In India, the Protection of Children from Sexual Offences Act 2012 criminalizes non-exploitative consensual sexual conduct of adolescents, and studies have revealed its discriminatory impact on adolescents and the inconsistent treatment of romantic cases by special courts. We believe this is an opportune moment to learn from the South African experience. The Centre for Child Law, University of Pretoria Clinic, played a key role in the litigation. Karabo Ozah will talk about the litigation strategy, challenges faced during the litigation, implementation of the judgment, and the status of rights of adolescents after the teddy bear.
For them, I know there's issues in relation to people with disabilities and whether having a blanket clause that says they can't consent to sex violates their rights. But anyway, today we're just focusing on adolescents. So that is what the law did. And then we can go to the second slide, the third one. So, I mean, this nice law comes into operation, but it also creates a bit of chaos. There was already an outcry from civil society who had been involved in the process of parliamentary process and who have made submissions in relation to the law. They already knew that, they've lost the battle in Parliament, so this law has come into operation and it has these clauses that are problematic. And the main one being what became the kissing clause. So what was that? Shivangi, I think it's the next slide. So what we came to call the kissing clause is actually the provisions that the lawmakers came up with trying to protect children. They claim to be protecting children from sexual abuse. So they actually criminalized all consensual sexual activity between children aged 12 to 15. And this included anything from kissing and hugging to penetrative sex itself. And I'll show you I'll come back to the provisions just now. So very clear that consensual sexual acts amongst adolescents were criminalized. And what, when that came out, there was quite a lot of stuff in the media in relation to how there's a new law, tough law means no more teen kissing. South Africa teens go kissing crazy. What happened is that a lot of young people, when they heard about adolescents, when they heard about the law, they wanted to challenge it practically. So they organized places to meet and have kiss-a-thons. And there was also a Facebook group, maybe. Are we all good? I see there might be an internet problem. Can everybody hear me?
Yeah, we can hear you.
Fine. Okay, sorry about that. I was just seeing a message on chat, so I just wanted to make sure that. So there were teenagers who obviously wanted to rebel against this new law. And from civil society and the South African Law Reform Commission, the Law Reform Commission had done a lot of work prior to the parliamentary process. And they've always said that you didn't need to have that clause to criminalize consensual sex amongst adolescents. And maybe I must pause to tell you here that one of the things that came up is that the law that the Law Reform Commission had given to the Department of Justice did not have this provision that criminalized consensual sexual acts. So then you go to the process where the parliamentarians are busy with it, and during the parliamentary process, one person says, well, we have to deal with these unruly teenagers, and one person said, well, if it's consensual, let's criminalize the boys. And another person in parliament, a member of parliament, says, we can't just criminalize boys because that would be unconstitutional. We have an equality clause in our constitution. And then what do? They decide to criminalize both children. So that's how actually they came to this provision. We even had the parliamentary minutes that we submitted when we were litigating that showed that no proper thought had gone into that provision, it was kind of reactive, and it really throughout the course of the life of this provision, it was always this kind of reactive kind of not well thought through response to teenage sexual activity. So law came into operation in 2007, and as I said, everybody was unhappy. Well, not everybody. Civil society working with on children's rights, working with adolescents. The Law Reform Commission were not happy with the provision, and we continue to mobilize from then. Say, you know, something is not right with this legislation. We can go to the next slide. So what did the law say? So basically the offending provisions that problematic was section 15 and 16 of the Act. Section 15 dealt with a penetrative sexual conduct, and it made very clear that if children, adolescents between 12 and 16, between 12 and 15 engaged in consensual sexual activity, both of them had to be charged. And then also section 16 provided that in the case where it's non-penetrative acts, what we call statutory sexual assault, they had a defense, which we call the closing age defense or the Romeo and Juliet defense, which I'll come back to. So they actually had already, the law had a closing age defense, but for the non-penetrative acts. You didn't have that defense if it was consensual sexual penetrative or sex. You didn't have that option, which was also a bit odd, because you would think that the defense would rather be suited for the most what would be considered the most offensive, if I can put it that way, in the light of the view of the legislature. You would rather have it for that rather than for the other act. But nonetheless, you could see that from there that the aim is actually to punish adolescents and to try and deter them from consensual sexual activity by criminalizing. That's basically what the law did. As the law came into operation, obviously now we had to assess what is the impact of it, what are the problems that this law is creating for us, so that we can start building towards challenging it. So if you can't show that it's actually having a negative impact, then maybe we just worrying about nothing. So we can go to the next slide so I can share a bit some of the practical issues that came once the law came into operation. So one of the first things, and I think Swagata mentioned that you also have similar provisions, is that there are also all these reporting obligations under our Sexual Offences Act. So we have a similar provision in section 54 that said that if you have knowledge of sexual offences against a child or a person with mental disabilities, you have to report it. If you don't report it, you are liable you can be convicted and you can get a fine or a term in prison. So what that meant in practice is that if you are a counselor providing sexual and reproductive health services to adolescents, even in the school setting, if they come to you and they disclose that, oh, I have my boyfriend who's 15 and I'm 14 and I need condoms, or I'm worried that he wants to now have sex, we've been kissing and touching, that meant that you had to report that for that to be investigated. And if you don't report, you're committing an offense. And you can see there, my next point is that actually at that time in South Africa, just after the law came into operation, our Minister of Health was preparing to roll out the HTC, the HIV testing and counseling in schools. And we had to actually meet with them and tell them that, we have a problem. You have this nice program that you are planning. However, the law under the Department of Justice says that if adolescents disclose to the counselors that they're having sex or they're sexually active, be it consensual, that there is an obligation for the counselors to now report them. And if your counselors don't do that, they're committing an offense. And actually, after an engagement with the Minister of Health, he actually held back in introducing the program and waited. Which was actually a sad thing, because the whole point of that program was to try and increase access to sexual and reproductive health services for adolescents, and particularly seeing schools as places where they could access it easily. But because of the Sexual Offences Act provisions of reporting and of criminalizing consensual sexual acts amongst adolescents, that whole program had to be halted for some time. And then the next slide. Another thing that is very, I don't know whether you all have that as well, which is still there in South Africa, very extreme, is the sex offenders register. So we also have a sex offenders register under Sexual Offences Act, which provides that if a person has committed an offence against a child or a person with a mental disability, they must be included in, once they convicted, their names must be in the register. And that included children or adolescents who commit consensual sexual acts with each other. They could be on the register. And it also provided that if you commit a certain number of offenses or accounts, let me put it that way, you could be on the register for life. Now you can imagine you do something consensual when you're 13, 14, now you're on this register for life, meaning that when you start looking for a job, your employer can find you on your name on the register. And actually there's an obligation in South Africa on employees to check people against the register before they appoint them. So it had, this potential long-term consequences or lifelong consequences for adolescents. And more importantly, the placing on the register also was automatic, even for children. Later, we had to do a different case, a different case where we at least won the solution that for children, you don't get automatically onto the sex offenders register. There must be a proper assessment of whether you potentially would reoffend, or whether you for lack of a better word, a habitual criminal and all that. There must be proper assessment. We can't just be putting children on this register for life without actually thinking about what it means for them. So that was one of the things that was happening. And actually there were quite a lot of children who got onto the register without, automatically, and there's some who are still on it. We actually are planning a different case to challenge and try and get some of those, some of them are no longer children now, but some of those people who were children when they were put on the register to actually be taken off the register. Then we can go to the next slide. One of the things that probably a lot of you deal with is the eventual father syndrome. Just as much as the whole decision to have this criminalization of both adolescents, as it was debated in Parliament, in practice, the same thing happened where you had this one particular father who actually called our center because he was angry that he has a daughter who's 15 and she's sexually active with a boyfriend of the same age. They go to the same school and everything, and he called us. He's like, yeah, I want to go and report them. And we said, well, you must just know that the law actually says that both of them will have to be charged. And he thought, oh, well, you know what, let me teach them a lesson. We're going ahead anyway. And what happened is that these adolescents were taken through the whole process, obviously charged, had to be questioned by the police, had to appear before the magistrate court, all the issues concerning embarrassment and stigma, which I think in the end, even the father regretted. And they went to Teddy Bear Clinic, who was one of the applicants in the case, and that's why the case is called Teddy Bear Clinic. Teddy Bear Clinic was worried because the children were made to go on diversion programs that are not suitable. They treated as sex offenders. So the diversion programs that you put them on are sex offenders programs, which I'll come back to, because the state kept arguing that, well, we're diverting the children, but you're diverting them as sex offenders. You're not diverting them to programs that actually help them. The next slide. And then, furthermore, I think probably you guys also have similar kind of scenarios playing out, but, for us, we had to collate and be mindful, be aware of what was happening with the implementation of the law. So while we were busy, we started litigating end of 2010, December 2010. And while we were busy with the litigation in one of our provinces in the country, there were teenagers that were now being prosecuted because they had sex, consensual sexual with one another. So you can see there were female learners in one school that were pregnant, and this was reported to the police, and they were interrogated. This resulted in six boys and one girl being charged in terms of the act. Later, the charges were withdrawn, but the point is that these children were taken through that whole process again of being interrogated, being reported, and actually having statements being taken from them. And the girls were vulnerable because of the pregnancies being visible at school. They were targeted and they were asked about their sexual activities and to determine whether they, is the people who made them pregnant were learners as well, or were they adults or things like that. I mean, that violates their privacy, and actually is kind of policing of their bodily integrity, violation of their bodily integrity. So you can see there that, just by virtue of being a pregnant teenager between 12 and 16, you actually run the risk, and these particular ones were the receiving end of the harshness of this law. Then we can move to the next one. So the director of public prosecutions kept saying that, when the adolescents are charged, both, they will not be treated bad, they go through diversion and all those things. Having said that, I mean, there was one other case. I think this is one of my last examples, but there was one last case where there were teenagers, 2 boys and a girl, who had sex on school premises, and somebody videotaped it. And initially, the boys were charged, and then after they were interviewed, the girl said she had consented, and the 3 of them were charged, and all this was splashed in the media. The girl, was politicians pitched up at her house trying to say how, she needs help, and if she did consent to sleeping with 2 boys and all those things. And the whole hype around this, the negative media led to eventually the girl taking her life about a year after this whole scenario, because the media did not die down. And one of the things that came out again in this case was the fact that when the adolescents went through this process of diversion, which the director of public prosecutions was claiming to not be harsh, they went again to a sex offenders diversion program where they're treated as if they are real sex offenders. So you can imagine again the impact of that. So that was one last case that illustrated the harshness, and at that point we were clearly building towards our litigation. We can go to the next slide. So I've already explained that Teddy Bear Clinic was one of our clients. Teddy Bear Clinic is still there. It's a very important organization that provides services to children who are victims of sexual offenses. They do a lot of great work, and they were very important for the litigation. So we started talking to them, and RepCan. We can go to the next slide. RepCan, which was an organization that was working on the rights of adolescents, it doesn't exist anymore. With our NGOs, funding is always a challenge. But so remember, the laws came into operation in 2007. We monitored the impact of it, and we're engaging with a lot of organizations as time progressed. But in the end, around 2009, we started talking to RepCan properly, and to Teddy Bear Clinic now, with all these cases that are coming up, to say we need to plan for litigation. And as they were now seeing these cases, particularly Teddy Bear Clinic with this last case of these 3, the 2 boys and the girl, then they were, also now sure that yes, now it's time now to start doing something about it. They can't continue to be drawn into cases where such negative results come out for adolescents. So we then started looking at potentially now litigating. Okay, so you can go to the next one. So one of the things that that was funny is that our clients, RepCan and Teddy Bear Clinic, were not exactly on on the same page in relation to how to package the arguments or the litigation. As I mentioned, Teddy Bear Clinic is more victim-centered and wanted to go with a different kind of packaging of the case rather than RepCan. RepCan basically was saying adolescents have a right to have sex. So why are we criminalizing them for consensual sexual activity? They have their own autonomy, and we are violating their rights by actually not allowing them to exercise those rights without this law hanging over their head. So you can see there were 2 sets of arguments. One set was on child protection, where we emphasized that dealing with consensual adolescent sex through the criminal justice system was an overreach that resulted in more harm than protection. And the other argument was the autonomy one, that they have the right to privacy and bodily and psychological integrity, and in which the state has a limited role in terms of intervening in their lives. So even though the former was the simpler argument and the less controversial one, we agreed to go with both arguments, and it was really more about how to frame it. One important thing, I mean, as I go, I'll make some comments, because Sagata sort of gave me a brief. One of the important things that I didn't put on the slides is that apart from having the right client, actually, we had to find the right counsel, the right advocate for the case. So, you know, when you have sensitive cases like that, you can have these lawyers in your country that are brilliant lawyers, but when they argue their cases, it's kind of all or nothing aggressive. But we had one advocate who worked with our center for quite some time, who had the right tone and the right temperament, because, you know, these are very controversial issues, and his temperament, both in the High Court and in the Constitutional Court, in how he presented the case and how he understood the child rights arguments and the organization and how we needed to package the case, really was very, very crucial as well. So even if you have these, you might have the most brilliant lawyers, but if they're gonna trying to present this case and end up maybe rubbing the judges the wrong way, or maybe presenting it in a more of a flippant way, it could actually create a problem for you. So you must also be mindful of that. So a further consideration was the timing. We were trying to see whether there could be public support for this kind of litigation, because we know these are controversial issues, and one of the concerns is always that people will not support us. And when that case with the two boys and the girl was happening, and the negative effects, and unfortunately with the girl kind of ending up killing herself, that is we call it the Jules High School case. And also with the case of the 27 girls in one of our provinces, we thought the time was ripe to actually to have a bit of public support to show that the law was having negative impact on the ground. So then we launched. We can go to the next slide. We launched at the end of 2010. We launched in December, intentionally in December, because it's a bit quieter. We launched our application and served on the state and everybody, and then waited. We can go to the next slide, Shivangi. So another thing to watch out for when you're litigating these kind of cases is obviously the people who are not on your side, and that is not only the state. So in our case, while we were busy with the litigation, we ended up with amicus curiae coming into the case, amici curiae, and one of the amicus was an organization called Justice Alliance of South Africa, who are kind of these very conservative organization based on religious convictions and all that, and they actually came into a case to say that what we are arguing is problematic, and that criminalization was necessary to maintain morality and to act as a deterrent to adolescents engaging in sexual activity because of the potential negative consequences of doing so. And in particular, they were targeting the issue of penetrative sex. So basically, they were saying that it's immoral, and consensual sexual activities amongst adolescents is immoral, and the law is good because it discourages that. We didn't expect this. This organization just sprang out of nowhere and jumped into our case, and we had to respond to that. Later, there were also other organizations that came up, at least Women's Legal Center and another organization called Toranang, who are a women's rights organization, who came in to say they agree with us because the law is having a negative impact more on girls. So from a women's rights perspective, the law is then problematic. So yeah, we can go to the next one. So I've already spoken about the Toranang coming in as well. So we then, insofar as packaging our case, I think you can go 2 down and go to slide 16. So insofar as packaging our case, we had to think about how to do that. Obviously, there are legal arguments where we say that, well, the law is not in the children's best interest. It infringes their constitutional rights to dignity and privacy, bodily and psychological integrity, which these rights are in our constitution. But also very important for us, we had to have support for these arguments, and we did this through describing the negative impact of the act that our clients that American and Teddy Bear Clinic had already seen in practice. And then we also got professionals to do expert evidence reports for us in relation to adolescent sexuality, and that proved very important because both in the High Court and in the Constitutional Court, those arguments, were referred to by the courts. And I mean, you must remember that when you're doing this kind of case where you want to use evidence, it's better to have all your evidence properly written up and submitted in the High Court already, so that it does already cover that. You can go to 16. Sorry. So, Shivangi?
I am on 16. I am on 16. Do you want me to go to the next slide?
Oh, it says page 14. So, sorry, let me tell you that 2 down. Go 2 down.
Okay.
Sorry about that. Yeah,
No
sorry,
problem.
I'm not counting the first one. Sorry. So I think insofar as looking at what the expert evidence contained, I'll just wait for us to get to that slide because I want you to see that.
So I'm just scrolling. Tell me when to stop, okay?
Okay, all right, I'll tell you.
Is it?
It's a slide that said the expert evidence. I wonder why that's frozen on my side.
No, just.
So there's a slide that starts with the expert evidence was
It's on
compiled
slide
by
17.
academic.
It's slide 17, Shivangi.
Okay.
Yeah.
Here. The expert
Okay,
evidence.
I think the problem might be on my side, but yeah. Okay, I'll continue, and then I will tell you to move on to the next one.
Sure.
So the expert evidence. Yes. Yeah. Okay. Thank you. The expert evidence that was compiled, we went to the University of Cape Town, and there was an expert there in psychiatry and mental health. And we asked them for a report, and we gave them a specific brief. And that report drew on published research to show how, adolescent reach psychological sexual maturity during that very period. Those ages that the law now criminalize them. That's when they're experimenting and going through, really being curious about their sexuality. And we said in the report, the report of the experts said, that's the time where the adolescents require support and guidance because it's a period of transition from and maturing, and the last thing that you want to do is to criminalize them because that will have lasting effects into their adult lives. So that was one aspect of it. And then on the next slides, the report also says that the study showed that sexual experimentation ranging from kissing or touching to intercourse are common and developmentally normative for that age group. This exploration is potentially healthy if conducted in ways which the individual is emotionally and physically ready and willing. So, the problem is that now once you don't differentiate between healthy and unhealthy behaviors, you're conflating things, and that will have long-lasting effects on adolescents. That's a point that the expert report made. Furthermore, the report also touched on the fact that what we shouldn't be doing is to have this criminalization, is that we think that it will deter sexual activity, but what the provisions are more likely to do is the opposite, which is the promotion of unhealthy behavior by driving sexual activity underground, as well as cutting adolescents away from access to reproductive health services. And probably you already, with your experience, you're seeing that once you have criminalization, it does have a negative impact on adolescents, and they will be, they won't come out to get services, and we know the consequences of that as well. Now then you are letting them expose themselves to risk behavior and conduct their sexual activities in a way that's not protective to them, and that is the serious problem. So The report also indicated that the provisions were likely to reinforce social stigma and taboos around sexuality, and that when you criminalize, you're actually impeding the children's rights to access contraceptive, condoms, and medical treatment, which our Children's Act actually provides that adolescents should, from 12 years up, should access. Just to up. I think you went a bit far. You need to go 2 more up. Yeah, the one before this one. So those are arguments that we put before the court, and obviously the state and the amicus put their own, this one, they put their own arguments. So I mean, for the state, their main argument remained that criminalization deters, and these adolescents are busy running crazy, and the only way to make sure that they behave better is by criminalizing them. You can go to 19. I think you went. So these were argued in the High Court. I mean, the arguments took 3 days because it was quite a substantive case. Because there was quite a substantive case, and there were the 3 amici, and the state also had the Minister of Justice as well as the Director of Public Prosecutions. You remember, I mentioned that the case was issued in December 2010. We only got the judgment in January 2013. That's when we got the judgment from the High Court. It was a positive judgment. Obviously, the judge upheld our arguments, and he actually said that the provisions violated the children's constitutional rights to dignity, privacy, bodily and psychological integrity, as well as their best interests, and that these violations were not justifiable. Shivani, you can go 3 down. Like, I've already passed this one. There's the one with the mark, the one with the picture. We can go to that one. So the court then made the judgment that the sections should be amended. Obviously, you need the Constitutional Court to confirm the unconstitutionality, and also the temporary reading in that was done into the provisions. And very important, the judge actually said that the evidence that the applicant had presented clearly indicated that the provisions may cause harm to children rather than actually deter them, and that was very crucial. That we had that evidence that showed that if you read everything and if you look at how so far it had played out, and if you look at development and research in relation to adolescent sexuality, having such a law will cause more harm than actually deter adolescents. So that was clearly there. So we had this very positive judgment that we were very happy about, but then in the media, there was a lot of backlash. So while the judgment was quite a resounding victory, the public opinion had gone back to being negative. And I think one of the things that in hindsight we realized was that around that time in 2013 or so, there had been incidences of children in school kissing, or children are misbehaving in schools, and everybody's worried about it. Now you have this judgment coming out that sort of people are like, oh, you see, even the law is making all these children become unruly, and now they have a right to have sex. That's what is causing all these problems. So the public opinion that we and support we had thought we had when we started the litigation had dwindled, and actually the media was very bad. We had to do a lot of damage control in the media. So right there and there, responding to the High Court judgment, we actually had to come up with a media strategy going forward, because we realized that we were caught off guard, and now this case is going to the Constitutional Court. If we don't tell the case or the narrative of the case in a way that suits us, the media is telling it in a way that actually is doing a disservice to the case. You can go to the next one. So we actually met with our clients and planned a strategy where we actually decided that we need to make key messages of the case. What were the key messages about the case? Some of the things that we said was that, you know, the key messages is that one of them is that the criminal justice system should not be dealing with consensual sexual activity amongst children. That is not the domain of the police, it's the domain of the parents. That the role of the state, insofar as this issue is concerned, is to have policy and legislation through the Department of Social Development and Education, where you take the educative approach, not this criminalization, and that adolescents should be empowered. I think I'm on slide 21 or 22. We also say that, you know, adolescents should be empowered by nurturing and caring adults to make good independent decisions about sexuality, again, not be criminalized. One of the things we did just before we went to the Constitutional Court as part of our media strategy, and actually we hired a media person to help us prepare for this. One of the things we did is that we actually had to make a list of things that the case is not about, because people were claiming that the case is about things. So we actually had a list of what the case is not about. And actually, even in our Constitutional Court papers, our advocate, our counsel actually started our submission to the Constitutional Court with what this case is not about. And we had that list because we were trying to upfront tell the court, tell the people that this is not what we're saying. So let me tell you what we said. We said that the case is not about challenging the criminalization of adult consensual engagement with children. That is a crime. The law is clear there, and that is not what we're saying is a problem here. The case is not challenging the criminalization of non-consensual sexual crimes committed by children. So even with children, if it's not consensual, it's still an offense. So we made that very clear. The case is not about lowering the age of consent to sexual activity. The age is there, it's 16. In the law, those who are under 12 in terms of the law are incapable of consenting. We leave it at that. The case is not about seeking to promote or encourage sexual activity between adolescents. It deals with treating children as criminals when they do engage in consensual sexual activity. So we were saying the problem here is the response of the state when adolescents do engage in consensual sexual activity. You're criminalizing them, and we have a problem with it. And also the case is not about changing or challenging the definitions of rape and sexual assault. The definitions are clear in the law, and we were fine with it. So that was the strategy we took to the High Court, to the Constitutional Court, and we did a lot of media. We wrote small, short articles for newspapers. We were on local radio station in different languages so that people can understand the message. We did quite a lot of work in anticipation of the Constitutional Court arguments. And I must tell you, you know, when one sits now and thinks back, I remember in the Constitutional Court, the Chief Justice asking the state, you know, over and over, how does criminalization deter early sexual debut? And they couldn't really give him an answer. And I think, you know, in as much as that judges are impartial and all that, I think in a way the message had gone out there that, well, you know, the point here is that you are bringing children into the criminal justice system for something that is constitutional. And actually we have other laws and other constitutional provisions that tell you how you should minimize the use of the criminal justice system for children. So now you are actually saying they've done something consensual, but you're bringing them in the criminal justice system. Whereas you're saying, even if they do something wrong and break the law, you shouldn't really be bringing them into the criminal justice system. You can divert them, you can have other responses to them. So we had to try and make that link. So basically in the Constitutional Court, we argue that there was no evidence that the criminalization will delay sexual debut, that the criminal justice system is not the correct response, and that the fact that the state keeps saying they get onto diversion programs is not the answer, because we had all these cases that show how the diversion programs work out, and that by the time you get diverted, you've already been interrogated by the police. You've already, you know, you have to come before a magistrate in the child justice court. So you're already coming into contact with the criminal justice system, and that is a problem. So in the Constitutional Court, we obviously were successful. As I said, during the argument in the Constitutional Court, the big thing was that, and I think we always structured our case to center around how does criminalization sort out. So the rationality of the law, right? Because the state has to say what is the rationale behind the law, and their reason is that, well, we're trying to deter early sexual debut, and all those things. But they couldn't prove it. There was no evidence to that, and the state and the court saw through that and say, but you can't say your law is there. You have this provision because you want to deter, but you have no evidence that it's actually working and will work. If anything, you are victimizing the very adolescents that you claim that the law is supposed to protect. And that was the hook that the court got for us. On the slides, one of the things, I will not read the slides out for you, but I hope Sonata will share the slides with you. One of the things that we got in the Constitutional Court that we actually did not even anticipate was a very nice judgment that clearly highlights how adolescents have a right to their own dignity. The court actually in the judgment has goes into that, and that you are now getting into their own private space, and that their right to dignity must be read together with the right to privacy. And these provisions are problematic because they violate both rights, and you're getting into the adolescent private space in a way that is not justifiable. And also then obviously tying that up with the fact that you're not protecting or promoting their best interest by bringing them into the criminal justice system. Those are the things that the Constitutional Court saw very clearly, and actually with the privacy and the dignity, very important. They obviously they give credence, or they support that argument about the autonomy and evolving capacity of adolescents, and and the need to respect them as they grow into their own individual being and become older. That is very clear in this very positive judgment. So we won in the Constitutional Court, and then obviously the law had to be amended, so it had to go to Parliament. Very, very important. The parliamentary process, the battle started right from the start. Again, there were obviously the religious groups. Again, the one that had been an amicus curiae filed submissions saying they still find this problematic, even though the Constitutional Court has said that the law is problematic. They find that the law is fine, it's there to protect. And we actually had to mobilize quite a lot as the children's rights sector to actually have groups in Parliament all the time where the law was debated, to make submissions about and remind, or sort of actually educate the parliamentarians about why is it that the law was problematic. And one of the organizations that we work with based in one of our other provinces, actually the province where the parliament is in Cape Town, they managed to even get teenagers to come and make submissions to Parliament about what they thought about the law. So we had to do all that so that we uphold that positive win from the Constitutional Court, because there was still the danger that we could lose again in Parliament, despite what the Constitutional Court had said. So that process obviously was successful. What we ended up with is obviously in the provision again stating that for both non-penetrative, which is the sexual activity, non-penetrative and the sexual, what they call the sexual assault, if the parties are between the age of 12 and 16, they're not committing a crime. If it's consensual, obviously very important, and that there is also the Romeo and Juliet clause where the age difference is not more than 2 years. The not more than 2 obviously came also already from the law had already, in relation to non-penetrative sexual acts, had the closing age difference of 2 years. So we argued for that rather than a bigger age gap, because rather than nothing. Was a contested debate in Parliament. Actually, even right now, I know there's somebody who is looking into, well, why did you make it 2 years and not 3 years? That it could still be problematic. So anyway, so that is the law after now. As I said, we have the closing age, or the Romeo and Juliet clause, and it's no longer criminalized. So that defense applies for both section 15 and 16 that I had mentioned in the beginning. So just quickly in conclusion, because we have to have time for a discussion. I think one of, just a few takeaways or learnings from us in relation to the litigation, the strategy and everything, is that firstly, we have to have the right client for this kind of case. At one point, we considered whether we should have children as applicants or adolescents, but we decided, no, we don't want to make them the poster child of this kind of case. As you saw, there's even an adolescent who took her life because of the negative effect of this process. So, Teddy Bear Clinic and RepCan were good clients because also they represented the kind of robust adolescent rights, kind of they have a right to have sex, and on the other hand you have the kind of measured Teddy Bear Clinic approach, and we managed to find a middle ground and package the case in a way that was good. That research and expert evidence that we put in right from the start in the High Court was very crucial, because you have to take court with you, and if you can show them that evidence shows that you actually what the law is doing is actually problematic, because this is a time where adolescents normally experiment, and now you're actually targeting that very age and making them criminals for life, and all those negative consequences of the register and having to be reported. Media strategy, very important. If you don't do your media strategy, the media will package the case for you, and that really, with the High Court, it had very dire consequence, or almost had dire consequences for us. I forgot to say that actually with the High Court, we wrote to the media and actually made them retract some of the articles and apologize for how they packaged the case and how they were misleading the public. Very important, litigation must go hand in hand with other advocacy actions. Litigation is but one tool. Apart from Teddy Bear Clinic and RepCan, there were a lot of other organizations that were supporting us, doing other things, writing short papers on these issues. And when we went to Parliament, we had more than just RepCan and Teddy Bear Clinic Center for Child. We had a broader kind of group of children's rights organizations and supporting it, which was very helpful. You need to be mindful of other related issues that could affect your litigation and arguments to counter these. One of the things I remember that Sagata asked me about was why we didn't use the brain science in this case. And we didn't, because in an earlier case that had to do with the criminal justice system and minimum sentences for child offenders, we didn't want to go the US way of brain science, because we thought if you're arguing that the brains have not developed and therefore they should not be criminalized, and then you get to this case and you argue a similar kind of argument, you're actually getting into a space where you might complicate things in relation to ability to consent. If you're saying that, well, they cannot consent because they have not developed, then that gives credence to the state saying, well, that's why we have the law that kind of protects them in a way. So you must always be mindful of, when you pick it in this case and you put in your argument, could it potentially affect other cases that you do in relation to children or adolescents in future, and actually be mindful of that. In South Africa, I mean, we were very encouraged by the judgment. Obviously, we lucky we got a court that was so progressive, and to recognize adolescent autonomy and their evolving capacity to consent. I think lastly, all of us, we need to continue to highlight how the criminalization has negative and long-lasting consequences for adolescents. I mean, we sorted out the law, obviously, but we know on the ground there's still big problems. A few years later, like 2015, 16, I did a study for UNFPA in relation to adolescent sexual and reproductive rights, and we did interviews in South Africa and other African countries, and in South Africa it was very clear that there's still not clear recognition of adolescents' rights to consent to sexual activity, to actually consent to getting sexual and reproductive health and rights services. So a lot of work needs to be done around those issues, and it doesn't stop when you just finalize or win the decriminalization. And I think I will end there. Thank you.
Thank you very much, Karabo, for that excellent and very comprehensive presentation. I think there'll be plenty of questions with